switch, please. Hopefully you guys can hear me now. Ship, I see you. I'm going to send you the co-host. See if you can hear me now. Aha, I'm getting waves and thumbs up. Finally, it's working this time. Terrific.
Loud and clear now.
Oh, fantastic. I don't know what that was because I've tried everything I could think of and I just had to start it over. I hate to do that to people. But if you can't hear, you can't hear. Okay, so hopefully King will be joining us here in a second. Hi, Jason. All right, so we've got Ship here for a few minutes tonight, and we thought we would try and talk about at least the Biden plea tonight. And we're still going to do Tuesday night and talk about Donald Trump's cases. We can talk about him every time because so much happens to him. So much happens to him. It's incredible. And so we're still going to meet on Tuesday and talk about the new scheduling order issued by Judge Chutkan. I know Ship has a lot of thoughts about that. And also Judge Marchand's ruling today saying he's not going to go forward on the sentencing in a couple of weeks. We're going to, hey, there's King. Let me send him the co-host. And let him in. Okay. And we're going to do all that next week. We had a request also to talk about the Elise Stefanik's new filing, sort of a ethics filing. Hey, King, can you hear me now?
Loud and clear.
Oh, fantastic. You're loud and clear to me now, too. I'm just telling the folks.
We're having to work around Virginia's dial-up modems.
Apparently, so the April still has not come out here. They claimed we're on the schedule from the end of August through September 10th. So I guess we're getting there eventually on their work order process. And hopefully that's going to solve our problem when we get that new cable laid. So, all right. So I think we've got enough folks here. Let's launch into it. We were going to talk about Hunter Biden's plea yesterday. I wrote an article about this and ran in the Federalist today. If folks want to go over and look at that, it's got some of the technical answers about like what does the rule require for Alford pleas and so forth. First thing I want to tell people, just so everyone is clear, is that Biden's lawyers proposed to do an Alford plea, but that is not ultimately what they did. They ultimately did a standard guilty plea. They just did it without a written plea agreement. So, Ship, King, how do we want to approach this particular topic? We want to explain Alford first?
Yeah, start with Alford, but I would jump quickly into did these lawyers have any strategy going in?
Right. Yeah. What was the strategy? Yeah. Okay. I know I have some interesting thoughts about that too. Okay. So to quickly explain the legal background, an Alford plea is a plea where the defendant is found guilty by the court, just like a regular guilty plea, but the defendant never acknowledges personal guilt. They don't say, as you have to in a regular guilty plea, that you are pleading guilty because you are guilty, that you agree that you've committed the offense. The Alford plea is called Alford because it comes from a Supreme Court case, North Carolina v. Alford, in 1970. And in that case, the defendant was charged with murder and he wanted to not go to trial on first-degree murder. He wanted to plead guilty to second-degree murder, but he also proffered a statement to the judge saying that he was not the shooter in the case, which probably didn't matter for second degree, but it was at least somewhat an assertion of innocence, and he was basically not accepting full responsibility for the offense. And so the question was, because it was a death penalty case, and he basically took this plea in order to avoid the death penalty, the legal question was whether this was coercive, wasn't a voluntary plea, was somehow violated the Fifth Amendment. Supreme Court said no, they didn't think so. They thought that sometimes a defendant could make an intelligent and knowing decision to plead guilty to something, even if he himself maybe couldn't bring himself to say he's guilty of the offense, because that was his best legal option and that the facts in the case supported guilt. So the general rule is you cannot plead guilty in this country just because you want to, like just to get the case over with. If you can't admit guilt to the judge, and or if the judge cannot find that there's a factual basis that you actually committed a crime. So in standard guilty pleas in federal court, and in most of the state courts, pretty much in every plea, the judge at least listens to facts from the government that the government says establish all the elements of the offense. Now, as a practitioner, what people will do is, even if the government's facts maybe are very thin or arguably don't even establish the elements, but if the prosecutor says that they do and you don't object as the defense lawyer, unless the judge is really going to dig into it and say, well, I don't think that constitutes the offense, then basically the judge goes along. Now, not that the judge is doing anything improper. It's not like the judge is saying, well, you didn't commit the offense, but I'm letting you plead guilty to it anyway. But they kind of don't critically, minutely examine the prosecutor's facts. They let the prosecutor put their facts on the record. If it sounds like it satisfies the elements and nobody objects, then the plea moves forward. That's not what happened, as I'm sure we all remember, in Delaware when Biden tried to plead sort of guilty, sort of pretrial diversion, in this case in Delaware, to wrap up all of his problems. So, but in an Alford plea, you kind of do both. You kind of say that you're not guilty, but you agree that you legally can be established or found to be.
Okay, Leslie, if you're hearing me, you're going in and out. I don't know if you're going in and out for everybody else, but I am not. I'm only hearing portions.
Me too.
Okay, so
Leslie, did
should I
you hear
read?
my comment?
Yes, I did. Can you hear
We
me?
can now, yeah. So
Okay.
don't.
Should I recap the
No,
Alfred
no, no.
again,
We only
or?
lost like 10 seconds.
Oh, I see. Okay. So basically, the Alfred plea is a way to get to final, is the way I always thought about it as a defense lawyer. You have a client who maybe doesn't think he's as guilty as the government does, or we think the client can't bring himself to say, I am guilty. But the evidence is there. We know he's going to get convicted if he goes to trial. And so, if the government will agree, or if the judge will agree, you can sometimes use this Alford procedure to get to a plea. You avoid the trial. The client gets credit for accepting responsibility in some measure, and the case moves forward. The other place where you see this is where the defendant has maybe a legal defense that has failed. Um, and that was basically the defense that they had, and they wanted to raise that legal defense with the judge, um, and hoping that would win the case for them and they could avoid the trial. And then when that doesn't happen, but the client still believes in their legal defense, they think that they are not really guilty, then sometimes the Alford can be a device to use in that case and get a final resolution also. The other way you can do it in federal court is you can do what's called a conditional plea. I did one of these in my career. That came into the federal rules in 1993. I did one in 1997. And basically, you can condition the plea on the exercise of usually an appellate right. So this is built into the rule. It lets defense lawyers litigate issues pre-trial, and if you have a good legal issue that is not going to help you to the jury, but you think as a matter of law um, is a defense that the appellate court will uphold, what's the point of sitting through jury trial, right? You're just wasting everyone's time. And so, like First Amendment is the issue I had in my case. Then you could litigate that pretrial. The judge rules on it. Maybe you can plead guilty on the condition that you get to raise that claim in the Court of Appeals. And if you win on that claim, then it's obviously going to reverse your conviction. So
Well,
that's
let
another
me, I'll just
device
jump in
that.
there. Let me jump in just to say the most common instance of that is in a denial of a suppression motion, where there's a legal claim that the search was illegal, the the inculpatory evidence was seized during the search. You're certainly going to get convicted if that evidence is used. You move to
Comes
suppress
in.
and you
Yeah.
lose. So you know you're going to lose the trial. There's no point in having a trial. So you condition your guilty plea on being able to appeal the denial of the suppression motion.
Right. And so you could have seen this case as an example of that, right? Because Biden has these legal issues about whether the diversion agreement means that this tax case shouldn't exist in California at all. He's also got a claim that the special counsel Weiss is wrongly appointed. It's not quite the same claim as Donald Trump's claim about Jack Smith not being properly appointed, but if the prosecutor is not properly appointed, then the case probably shouldn't exist. And but that's a legal argument, not for the jury. So it's also my understanding that Biden has raised at least some issues of prosecutorial misconduct in his case. So he's claiming, that the case was brought for political reasons, so forth. Those are the kinds of arguments that are you can't even put in front of the jury. And so if he were to win on those with the trial court, great, but he didn't. He lost all of those motions. So he could, in theory, have negotiated a plea with the government to do a conditional plea and bring those issues up on appeal. I don't know if they tried that or not, but I suspect that they either didn't because they didn't think these prosecutors would agree to it, or they did try it and the government said no way, because normally they do say no way. They don't want to do conditional pleas. King, Ship, do either of you know whether or not there was an effort to do a conditional plea in this case?
I've not seen anything along those lines. Everything
Those
that
lines.
anybody
Yeah,
has written on this suggests that there were no discussions really uh,
beforehand,
beforehand.
right. I think that's right. Doesn't it look like Lowell, he surprised this. He did this as a drama play and this was his plan all along was to I think create consternation uh, and drama because he could have just marched into court yesterday and told the judge, we want to plead guilty to the indictment, right? Um, he didn't have to try to go for the Alford plea. The difference between the Alford plea and just pleading to the indictment is on the Alford plea, technically the defendant doesn't admit guilt. And then later on, if the person gets sued for stuff, then the case can't be used against him in the same way that a guilty can normally be used against you. But really, that's kind of the only difference. Um, the sentence is going to be the same. The factual basis is going to be whatever it is. And so there's not a lot of difference between the two things. So why do we think Abby Lowell tried to swing for the fences to get the Alford plea?
Before you get to that question, I have a question for you.
Go
The
ahead.
Alfred plea fundamentally is based on the proposition that the defendant claims he's not guilty,
Right.
which means he's not accepting responsibility, which affects his sentence. So is it really a win if he gets to do that?
Well, he is accepting responsibility legally, right? That's the beauty of the device is that he's saying under the law, I will accept being determined to be guilty and I will accept the sentence for whatever goes with that. But I am, helping the court out by not putting everyone through the expense of a
Yeah,
trial.
I'm going to jump in and
Sure.
disagree here. That does not fit the definition of acceptance under the guidelines. So I don't
Well,
think
okay.
I understand your point. I
Okay.
understand your point as sort of a
Yeah.
literal matter. but the guidelines has
Yes,
a
exactly.
more robust requirement to get that acceptance in as contemplated by the guidelines. I think this was
Right, but
mostly.
that doesn't mean the judge can't take it into account in the overall determination of the sentence because the guidelines is a technical analysis, right? I agree with
Agreed.
you
Yeah, yeah.
that
That the
yeah,
judge could say, I'm not going to give you two levels in the guideline calculation. However, under the 3553A factors, I am going to take into consideration, that you did not put the government to the burden. You did not require jurors to come here and sit for 3 weeks. The
right.
extent that you proffered a defense, it wasn't a defense of I didn't do this. It was more in line with. And see, this is where I think the reason. I don't think this was technically an Alford plea as I understand them. This was more I have an affirmative defense, but I'm going to opt to not put it forward in a trial. But my affirmative defense is XYZ. I think that's what we're going to see in the sentencing documents. So it's kind of an.
And that affirmative defense is what I'm talking about with the case shouldn't have been brought at all because of the
No.
diversion
I think it
agreement.
is. I
That
think it's the drug addiction and all that stuff.
I agree with
oh, I
Ship.
see.
I,
Mitigation.
I yeah, I
Mitigation.
sensed that
Yeah.
he was claiming he wasn't guilty because he was stoned and
Yeah,
on
that he.
on drugs throughout.
Yeah,
Right.
that
Okay. Well, he got
all of these efforts to acquire revenue by hook or crook or to feed his addiction, and in fact, Judge, just look at me on all these videos. I'm clearly out of my mind.
well, nobody disagrees with that. Well, he did get a lot of bad rulings from this judge in limine about that evidence. He had a lot of evidence he wanted to put in his case, and the judge told him, no, you can't do that because that's not a defense, that's mitigation, right? Which is for sentencing. So, if that's the thing that Abby's trying to do, then right, there was no point in sitting through that trial because he couldn't get a not guilty out of the jury based on what the judge told him he couldn't do a trial. Um, but so if okay, he's still going to raise that stuff at sentencing. We agree as mitigation at a minimum, right?
Yeah, and I think he was trying to use it. That's why I said I don't think this was sort of an imperfect effort on an Alfred. He wanted to use mitigation effort. He wanted to use mitigation evidence as an excuse to not have to make an acknowledgement of actual guilt, although
Mm-hmm.
the evidence of his conduct was overwhelming.
Right. Now in law school we learned that's kind of a voluntary intoxication defense, which almost every place rules that that's not a valid defense, right? You can't say, well, I robbed the liquor store because I was drunk. Okay, well, who drank the alcohol that got you drunk, right? That you did. So and there's by contrast there is a defense under the law for involuntary intoxication. If you and I've seen this work once in state court in Virginia, if you are intoxicated at the time of your offense and you do certain things because you are out of your mind, and that is as a result of like a medication uh, conflict, or you were drugged by someone unbeknownst to you, that is a valid defense under the law. So it sounds like what he was trying to raise is what I would have called a voluntary intoxication defense. So if that's the situation, it shouldn't really have it been a surprise that the judge wouldn't let them do that.
Uh,
What do you guys
well,
think?
I think they were kind of hoping that the prosecutors they sprung it on the prosecutors with the hope that maybe the prosecutors say, okay, fine, let's just get it over with. That they
Yeah,
wouldn't
that
that
didn't
in the end
happen.
they wouldn't care. But I mean, I could be wrong. I presume maybe he had somebody working with him that's got experience in the Ninth Circuit. I mean, I just am very familiar that there is significant legal precedent in the Ninth Circuit that a judge cannot take an Alford plea without the consent of the government.
But
Right, and see that if there's good case law on that in California, then it is. But the rules don't say that, right? um, the Alfred case itself certainly does not say that the government has to agree to it. It's basically between the defendant and the judge. And the Federal Rule of Criminal Procedure 11 does not say that a defendant can only plead nolo contendere, which is what the federal court calls an Alfred plea, with the consent of the government. It says with the consent of the court, not the government. So
And that, well, it might be, because I haven't read the case in a long time, and I never actually had to even confront it myself. It might be that the case or cases that I'm thinking of were circumstances where, in the facts of that particular case, the judge refused to take it without the government's consent for some reason
right,
particular to the case, and then the defendant lost on the basis that the judge was not forced to take it. The judge could decline to
right.
take it. And in this instance, or in the instance of that case, the judge declined because the government would not agree, and there was some justification for that.
Right. Well, the rule does say that the court is supposed to take into account the parties' views and the interest of the public in deciding whether or not to accept a nolo contendere plea.
Let,
And interestingly, the Supreme Court itself added that language, not the Rules Committee.
but bottom line, I have always understood is it's one of those things that a judge has discretion and will
Right.
listen to both sides. And if you
Yes.
show up like Hunter did the morning of the trial and spring it unannounced upon
Yeah.
the government and the court, and the government pushes back, uh, it's a flip of the coin as to whether the judge is
Right.
going to buy your
Right.
argument, and which boggles my mind. Why didn't they raise it sooner?
Right. See, I think this was intentional. I think this was designed to distract from Lowell's actual purpose, which was to get a plea put forward with no agreement with the government, um, and avoid the trial. So here, bear me out on this. So for one thing, Lowell was arguing to the judge that the judge had to accept the Alford plea if the defense proffered it. And I was astonished at that. I've never heard that that was the law anywhere. Would you guys want to comment on that? That the defense could force it. I think that's truly wrong.
I've never researched that issue because the practice in my experience has always been uh, you you get the judge to agree and to increase your odds of that happening, you get the government to agree also.
Agree
Right.
first. Right, exactly. Yeah, Ship, have you ever heard anyone argue that the court had to accept an Alford plea?
No, but I've heard a lot of defense lawyers argue a lot of things that weren't supported,
That don't turn out to be the law.
including
Right.
myself.
Yeah. Well, I was researching that. I'm like, no, I don't think that's right. And when I reread Alford yesterday, the Supreme Court actually said in a footnote that they definitely were not saying that a judge had to accept such a plea. So, I mean, straight out of the horse's mouth. So, I don't know what case Abby Lowell thought he was relying on, or maybe he was just trying to, strong arm the court. But that I think was clearly wrong. That the court does not have to accept the plea just because the defense wants to do one. But at the same time, I don't think that I don't think that the prosecutors have to agree either. I think the judge gets to decide. It sounded like this judge wasn't going to reject it out of hand, but he wasn't going to take it because Abby Lowell told him he had to either. Um, and he was going to consider it. But then Abby Lowell said, "Well, Judge, why don't you let us talk about it?" And they went out in the hall, right, and talked about it. And they come back, and lo and behold, after jumping up and down and telling the judge that Hunter was never going to admit guilt, they came back like an hour later and had worked out a guilty plea. Now, not with any agreement, right? They just changed their position, and the government can't really do anything about this. Lowell changed his position and said Hunter would plead guilty straight up to the whole indictment. So there seemed to be a lot of confusion about this in the reporting yesterday, and I'm not surprised that the reporters were confused. But when you look at the docket, both the docket entry and the memo that the clerk submitted for that docket entry shows that it was not an Alford plea that they ultimately did. It was a straight guilty plea. He just pled to every count in the indictment.
He,
So that's why I think this was all a show by
he
Lowell about this Alford.
Leslie, he went even further. The judge read him every paragraph in the indictment, and he agreed on the record that it was true.
Hmm.
Well, okay, so but
Right.
that raises an interesting point because when there's no plea
Yeah.
agreement, there is no agreed upon statement of facts, and so that
Right.
the factual basis, and I apologize, I'm standing outside in the wind getting ready to get on a bus. The factual basis sort of has to be established on the fly, and I've
Right.
done a couple of these in more than a couple. I've done 4 or 5 in January 6 cases where I am not prepared. My client's not prepared to accept the plea facts as written by the government. So we plead straight up and we draft our own facts. I generally give that to the government a couple of days ahead of time. I give it to the court a couple of days ahead of time because I've taken the position and the judges have agreed that if the facts are sufficient as to every element of the offense, the government doesn't get a vote.
That's good
Uh,
enough. Right. That's good.
right,
That's what the rule says.
right.
The judge is supposed to determine. Yeah.
But
Right. Now,
you kind of pave the way to make that happen if you give that statement to the government and to the court in advance. When you walk into the courtroom like you all did yesterday, and you've got nothing, then the judge says, "Well, let's just read the indictment and see if it's true."
right.
You
Right.
turn
Well, what
you turn
happened
you
was
turn
the
you
judge
turn allegations into a confession.
into the truth. Right. Well, what happened was the judge said, I can probably take this plea if there is some statement of facts sufficient for me on the record, right, of guilt. And then the prosecutor, Leo Wise, said, well, if we're going to go forward on this, then I'm going to read the whole indictment into the record. And I thought that was the dumbest thing I ever heard because the indictment's already on the record. You filed it in open court. It's part of the case,
Yeah, but the
right?
defendant has to orally. The Rule 11 has to be the oral colloquy. So the
Yes,
defendant has to
except
stand there and it has to be read and he has to acknowledge it with a verbal affirmance that is captured in the transcript, but the judge and the public hear it.
if it's a guilty plea. But if you read Rule 11, if it's a nolo contendere, then the judge does not have to establish the facts. And the rules, the notes to the rule specifically say that that's intentional. That for nolo contendres, the defendant can basically just say, "I'm not contesting this,"
But
and that can be good enough for
I'll
the
tell you what,
judge.
though, I've never heard of a federal judge accepting a no-low plea because
No, me
the
neither.
principle of a no-low plea puts the judge in the position of sentencing somebody for a crime that they deny happened, and that sort of
Right.
is contrary to the So rather than accept the no-low plea, what the judge would do is say, "Let's bring in the jurors. The jurors will solve the
Right.
problem."
We're having a trial. That's what we're having a trial for. Right. So, but interestingly, the rule also says that Alford pleas basically are treated in federal court as nolo pleas because the rule says there's only 3 pleas in federal court: guilty, not guilty, and nolo contendere. So, because Alford is sort of its own thing and arose in a state court case, the federal court has basically said Alfords are nolo contendres. So, when Leo Weiss jumps up there and says, well, I'm going to read the whole indictment into the record, but all of these lawyers and the judge were missing the point that for an Alford plea, there didn't even need to be a factual basis for the judge to accept it. Now, I agree with you, most judges wouldn't. But this idea that, well, you're reading the whole indictment into the record to support an Alford plea is kind of like not the way Alford pleas work. So now Alford itself, the Supreme Court there did emphasize that because there was overwhelming evidence of guilt, that's what made them comfortable that at least it wasn't unconstitutional to take this kind of a plea. But what struck me was Abby's just dumping in the middle of the table this, bag of shit Alford plea assertion, and nobody seems to know how it's supposed to work, right? What the rules are, how the rules apply, what the procedure is supposed to be. And Abby's saying, "Oh, you have to take this plea, judge. You don't really have a choice." The whole thing looks designed to me to be creating this angst situation because the fallback plan the whole time was to just straight up plead to the indictment.
Well, but also think back to the Maryland fiasco or the Delaware fiasco. Remember, there
Right.
Abby's sitting in the audience and he's watching what was supposed to be a wink and a nod plea fall apart.
Plea. Right.
And so
Exactly.
I think he was hoping that just like the prosecutors in Delaware were willing to go forward with wink and a nod. It was the defense
Right.
that screwed that up. The defense lawyers,
Right.
and then when the judge questioned Hunter a little more closely, Hunter said no, he wouldn't, accept the diversion agreement without the waiver, if I recall correctly. Um,
Right.
so, so I think so this was. Yeah, I mean, Abby Lowell has a reputation that's well earned, and I think this was Abby just trying to Bigfoot everything and hoping the prosecutors would
Yes.
just, with a wink and a nod, go along like he thought had been arranged and then screwed up in Delaware.
Or else that they would just be so disconcerted by this, right, that they would make mistakes and that the judge would go along and be on his side. That almost happened. So, but then did you guys notice as soon as they were finished in the courtroom, because later they came back and they did a straight plea. And Hunter, as King is saying, Hunter said, yes, these facts are true. And I admit that I'm guilty and I agree I'm guilty and blah, blah, blah. So it was a straight plea to the entire indictment. Okay. And then Abby Lowell went outside and talked to the press and was talking about how he's going to appeal the case.
But that goes back to the question. There are some issues, legal defenses that you lose. If you press them and you lose, you can plead guilty and still appeal those legal defenses. You can say,
Right. There's
so he
yes.
has more. He can. You can't appeal on the basis of insufficient evidence.
Right. Or all these motions in limine about this defenses that he wanted to raise. That's not going to work either. But what he can, I think, raise, well, for sure he can raise the issue of prosecutorial misconduct, but that doesn't look like a strong argument to me. I think what he's going to try to raise, because what you are allowed to raise, even though you pled guilty, if you have no plea agreement, that's the difference. If you have a plea agreement, the government makes you agree that you're not going to appeal all of these arguments that otherwise you might be able to appeal. But with no agreement, you can appeal whatever the law allows you to appeal. And one of those things is whether something is jurisdictional. And I think he's going to try to convert those two arguments that Weiss isn't properly appointed and that his diversion agreement meant that the case shouldn't even be in California anyway into jurisdictional claims. But the government would never have agreed to allow that as an appeal. Do you follow what I'm saying? I don't think they would have done a conditional appeal for him. Do you
I'm
guys?
not sure about that. Why not? Why would they not consent to a conditional plea? By the way, Leslie, I've had one of those too in my career,
Yeah.
and
Uh-huh.
I, it the government didn't really push back at me, and because they thought I'd lose the appeal, which I did.
Right. Yeah.
But if the government believes it has a strong case on appeal, why not take a conditional appeal?
Right. Well, that would make sense and it would be logical, but I haven't found dealing with prosecutors to be terribly logical
Well,
over the
I think
years.
there was another whole consideration here that we haven't mentioned yet, and that is that even if he takes the appeal, Hunter's going to have to take the pardon before January 20th if Trump wins. So it's unlikely that there's even going to be time for an appeal. And then even if Harris wins, I think even if Harris wins, Hunter's still going to have to take a pardon before January 20th. I don't know that he necessarily wants to let his fate ride on whether or not Harris will give him a pardon, because there's not a lot of
Right.
love lost between the Bidens and Harris and her staff.
Right. Well, I don't think this prosecutor's office would agree to give him a conditional plea, or at least Lowell was afraid that they wouldn't, because they keep getting hammered with this. You're giving him a sweetheart deal, right? You're doing special things for Hunter Biden that you don't do for other defendants. And it is not that easy to get a conditional plea out of them. They don't want to do it. Basically, their argument is that's what trials are for. the prosecutors don't actually view the conditional plea rule the way that I think it's intended to be used according to the Rules Committee, which is to try to avoid trials in cases where you don't have to try them because the defenses are legal. Pretty much they don't want to do that. They say, well, that's what trials are for. So I think Abbey decided he couldn't get the government to agree to let him appeal the stuff he wants to appeal. So he decided to do this instead. And in order to make that go down easier, a regular plea with the judge, he decided to swing for the fences with his Alford idea and then fall back to just a straight up plea. What do you guys think?
I agree with that. I agree with that. That in the back of his mind, it was always, well, if we have to just plead straight up, we'll plead straight up. But maybe we can jam this through, and nobody's really thinking through the implications.
Right. Right. Because if he had tried to negotiate it with the government, they would have seen that he wanted to appeal certain things and not others. And they would have tried to strong arm him and say, no, you have to waive those. But if he just pleads the indictment, they can't force him to waive his right to appeal.
It,
Although, Chip, we know of at least one case, don't we, where a judge wouldn't let the client plead guilty?
uh, that dynamic applies in every case, though.
Yeah.
If I'm a defense lawyer and I think I have a good legal basis to appeal that's jurisdictional, say, that's something I can raise on appeal, even with a conviction, with a guilty plea. Uh, Either way, I still have that right of appeal. And the government doesn't really lose anything by agreeing to take a conditional plea, do they?
No, but again, you're applying logic. And my experience has been that they just don't like it. They think the case should be over. You should plead guilty and get your sentence, and then they don't have to deal with you
But
anymore.
then my comeback is, well, I'm going in tomorrow and my client's going to plead guilty without an agreement
Right.
and we're going to appeal the
Without an
damn
agreement.
thing. And they can't
Right.
do anything
Exactly.
to you.
They can't do anything about that, right? Except they never see that coming, right? Because most of the time prosecutors are negotiating pleas not before the indictment, but not after the indictment, but before the indictment. And before they indict you, they can say, well, we'll indict you for even more stuff, right? If you won't agree to plead guilty and, or we'll agree to take things off, or we won't indict the wife if you plead guilty, blah, blah, blah. But they often lose sight of the fact that once they file the indictment, it is a tool that the defense can use to just plead guilty to the indictment. You don't have to get the government to agree to anything because they become irrelevant. You can just talk to the judge about all the stuff you want to talk to them about. Um, and the government loses control of a lot of the issues, but they don't see that coming because most of the time, people don't want to plead to the entire indictment. Even after they get indicted, they try to negotiate a plea to something less than the whole indictment. They might have to swallow the most serious charge, but the government will often agree to drop some of the lesser charges. And then again, as the defense, you don't have a lot of leverage usually in a plea negotiation, but then you have to deal with what the government wants and doesn't want, whether they're being logical or whether they're being irrational. But once you make the decision as a defense lawyer to plead to the entire indictment, then you don't have to care what the prosecutor thinks about things anymore. You only have to care what the judge thinks. And I just think that they overlook that many times because King, you're right that all you say is I can plead to the whole thing if I want to, and you can't do anything about that, Mr. Prosecutor. But that brings me back to you, Ship. We know of a case where a judge was reluctant to let the client plead guilty, right?
Well,
I've
it's
never seen that
it's like
before in my
it's
life.
like I'm not sure you can do that. Okay, so just the quick
Yeah,
story is, and it ended up not working out as we had hoped, but it was a gambit. It was a calculated risk. But Luke Denny, a January 6th defendant, had been he had been indicted improperly. The indictment that was handed down was more than 30
out
days
of
out of time,
time.
more than
Yeah,
30 days after his initial appearance, and so um, to solve that problem on the day before his arraignment, or a couple of days before his arraignment, a new indictment was handed down with a single count, and that was also out of time. But I could have probably so a decision was made just having plead guilty at arraignment to the single count and prevent the government
Instead of the 11
prevent the
that they
government
wanted to
from
bring.
indicting him
Yeah.
with multiple counts, which would have made a plea disposition more difficult. And so at the initial appearance at the arraignment, when they went through the standard process, which 99.99999% of the time ends what the pleas of not guilty, I just said my client wishes to plead guilty today. And it's like everybody choked. It's like, well, you can't plead guilty. It's like, well, you only do two things: you plead guilty or not guilty.
You only have three choices: guilty, not guilty, or nolo
Yeah, and
contendere.
so, and in fact, the judge was not going to allow it to happen. So, well, I'm going to have to research if you can do this. I said, well, I want the record to be clear that today, if the government does anything after today, the record for purposes of appeal should be clear that my client wants to plead guilty today, not 2 days from now.
Right, to this one count. Right. Yeah. So, right. I mean, this is astonishing to me that a judge would not let someone plead guilty. That is definitely not the way that should have gone. But it worked out okay in the end. The judge eventually did let you plead guilty. But okay, but because King's general point is correct that if you say I'm going to plead guilty to the indictment, really the judge and the prosecutor can't prevent you from doing that as long as there is, a factual basis for your plea. You're not pleading guilty, because you think you're Mickey Mouse flying to the moon or something. So the interesting thing is, it just really seems to me that Abby Lowell did that whole circus over this Alford plea because he wanted to distract everyone from the plea with no plea agreement, because he didn't want the prosecutors thinking too much about what he's going to do on appeal. Because he could have gone in there yesterday morning and said, Judge, we just want to plead to the indictment. But instead, he wanted to start with this Alford. Maybe he just thought, well, throw it up against the wall and see if it works, right?
That's the only thing that makes sense to me.
Right. So, and if he could get the judge around to a position where Hunter didn't have to say he was guilty, that would be even better. So, yeah. So, almost foregone conclusion, I think that there will be an appeal in that case. But do we think that those issues are jurisdictional? Do we think that the Ninth Circuit will let him raise those two questions as jurisdictional? Because the rule is if you plead guilty, you've waived everything, all your arguments, except those that the law does not permit you to waive, which is stuff like the judge gives you an unlawful sentence or your lawyer was not effective. And you have not waived any jurisdictional arguments. But are these arguments jurisdictional that Abby wants to raise, do we
Yeah, well,
think?
Judge Cannon in Florida has held that the issue of special counsel unlawful appointment is jurisdictional. She dismissed the case on that basis. So as to that one, I don't think should be much question. Although Abby doesn't have the same argument that Trump had in Florida,
Yeah,
because
Right, he's making the same
I want to
argument, but not for the
yeah,
same
I want to
reason.
disagree
Yeah.
just to a degree, on one extent though. You can raise on appeal arguments you lost even by pleading guilty. That, the waiver comes from agreeing to waive in exchange for something the government gets you. You do not waive your right to assert that the trial judge made mistakes.
the main motion that went to the issue of whether the indictment should fall on its face had to do with uh, the deal that got busted in Delaware that would have sent Hunter on a diversion program for the gun charges and let him
Mhm.
plead to a misdemeanor for the tax charges. Uh, and basically, he says, I had a deal and the government broke it, and they can't break the deal,
They
and
can't
they
do
can't.
that. Yeah.
And I think the Ninth Circuit would take that case as on appeal. I don't think he'll win it, but it's certainly appealable.
That argument sounds to me more like an immunity or a privilege defense rather than a jurisdictional argument. What do you think of
I agree
that?
with that, but it's the kind of thing that if he wins it, it throws the case out on quasi jurisdictional basis.
Right. Well, the government is certainly going to argue, aren't they, that these are not proper arguments on appeal. Like they'll probably file a motion to dismiss in the Court of Appeals saying this is an invalid appeal.
I think they lose that because it's not a part of the case that the jury ever sees. It's a pure legal issue.
Right, but the government is still going to say he pled guilty, which means he effected a general waiver. I don't agree with Ship about that. I think the law clearly is that a guilty plea is a general waiver of your right to appeal, except for things that the law doesn't allow you to waive, because otherwise it's not a final judgment, and the courts clearly think that a guilty plea is a final judgment. I'm looking for the rules too. I'm pretty sure the rules talk about that, but let's say, for the sake of argument, that that there is an appeal. I think it's pretty clear that the government will first try to knock out the appeal itself by saying it's improperly raised. You don't think so, King?
Yeah, they'll argue that, but first they lose on the appealability of the special counsel appointment. That clearly is
Yeah.
jurisdictional. The second part on the plea deal that the breach of the agreement that the defendant had with the government, um, it touches on jurisdiction. So they may agree to hear that.
Maybe.
Maybe, but
I'm not
I'm
persuaded
not
of.
sure.
Yeah,
I'm
maybe.
not sure.
Yeah.
I,
Right. Me neither. Yeah. Right. I'm not sure either. Now, the issue of prosecutorial misconduct, I think that's definitely appealable. So he could, I think, have keep his case in the Court of Appeals, and but maybe not be able to raise all the arguments that he wants to raise.
uh,
You see what I'm
I
saying?
see what you're saying. I'm not sure about that one either.
Yeah. So we will see. I just think it's a foregone conclusion that the government will try to kick that appeal out. And, whether they can or not, it's anybody's guess. Maybe they'll be able to keep part of it out, part of it not. But, the trial judge in this case ruled that that diversion agreement was in effect, but somehow hadn't started yet, right? Because the probation officer hadn't signed it, which I thought was
It was a
bizarre.
bizarre holding. I agree, and uh, I thought Hunter had a decent argument on the enforceability of the agreement.
Yeah, I do too. Um, and I've always been on that side. Our good friend Margot Cleveland's on the other side. She thinks that agreement is not enforceable, but as a defense lawyer, I think that agreement is fully enforced, and does mean that the subsequent cases are not properly not properly being brought. But you can never, when you're the defense, you can never underestimate the desire of the appellate judges to not rule for the defense, right? To not give the guy a new trial, to not say that he was not entitled to be tried in the first place. So you're always working against that sort of unconscious limitation in their views. So we'll see. It's sort of like the Jesse Smollett case. That case could have gone either way, right? That he was. So you see, Jesse Smollett's case went one way, Bill Cosby's case went the other, kind of on the same arguments that they had both changed their position in relying on what they were told by the prosecutor's office. And in one case, Cosby's case, the courts of appeals said that's right. You can't try him for a case that he relied on the prosecutor saying they were going to pass on. And in Justice Smollett's case, the different court of appeals went the other way. So it is sometimes very hard to tell exactly what the appellate court is going to do with this kind of argument. But Lowell, I think, he's litigated that in both courts, right? Both in Delaware for the gun case and out in California for the tax case. So he clearly thinks that's a good issue for him.
Yes, he does. And we should see two appeals, two different circuits.
Right. Exactly, on that. So that'll be fascinating too. Well, Ship had to drop off because he had to get on the bus. He's traveling today, you guys. So he flew, and then he texted me and said he could fit us in here for a few minutes before he had to switch to a bus. I guess he's doing the trains, planes, and automobile thing to get home to his family tonight. So Godspeed, Mr. Ship. And we'll see you guys again on Tuesday. We'll talk over the Trump cases, as I mentioned. King, do you want to say anything to wrap up finally about Hunter's plea situation?
I guess the $64,000 question, and that just shows my age, but that the $64,000
Go
question is
Google that, you guys. If you don't know what that means, Google that.
that is uh, whether and when he'll get a pardon or a commutation.
Right. We're not buying this, right? Say again.
I missed you.
I
You
said we're not buying these statements from the White House that they're not going to issue the pardon or the
oh hell
commutation.
hell no. With that, I think we can wrap it up.
Okay. Oh hell no. All right. All right. Good night, King. Good night,
Good
everybody.
night.